used to represent India abroad. And it was my job to defend India abroad. And there is much that we have in India that we can be proud of. But there are also, sadly, much that we have to be deeply ashamed of. And what troubles me and has troubled me over the last 4 years and a half that I've been on the Commission is that in India, while we celebrate our successes, we tend to completely ignore, we tend to forget these massive failures of which we have to be so deeply ashamed. And though the number of deaths that take place in these encounters all over India, though in absolute numbers they perhaps pale into insignificance against, let us say, the numbers of female feticides, where about 250,000 Indian girls are killed in the womb every year by their parents, or from deaths from starvation and hunger. In those cases, it is perhaps the neglect of government, the unwillingness or the indifference of public servants. But in the case of encounter killings, it's an actual act of murder. These are public servants sworn to uphold the law who kill. And if a public servant, particularly an armed officer of the state, thinks he can get away with murder, then obviously he'll think he can get away with anything else. Which is why it is so important to focus on this absolute outrage of encounter killings. And the sort of pattern of encounters that Mr. Gonsalves spoke about, that Mr. Mukul Sinha spoke about, is a pattern indeed that persists throughout India. The largest number until recently of these killings took place in UP. Huge numbers of killings, and took place largely for 3 reasons. And I suspect those 3 reasons apply in Manipur and elsewhere as well. Some were criminals who could not be put away through the judicial process, and therefore they were killed. The others were innocent victims who just happened to be in the wrong place at the wrong time. And the third, which is the most tragic and the most unconscionable, are those who were killed for reward, in hopes of getting an out-of-turn promotion or a gallantry award. And this, from the reports that we get, particularly in the Northeast, seems to be a driving motive, particularly for the Indian Army. Because every report we get has a glowing coda, a last paragraph, that describes the particular act of heroism of one or two of those who took part. And invariably, under the limitations that Article 90, Section 19 of the Protection of Human Rights Act imposes on us in dealing with cases pertaining to the Army, we always ask, did this person, this officer, get an out-of-turn promotion? Did he get a gallantry award? And the Army is extremely coy about confirming this. So, it is absolutely the case that a very large percentage of those who are killed in what are called encounters never, at least in that particular incident, fired at the police. They were usually either abducted and killed or just were killed. We have always tried, particularly over the last 3.5 years when we have focused very exclusively, heavily on encounter killings, we've always tried to get the police and the armed forces and the paramilitary to explain to us how, in a particular case, they established that this person had killed. They said there was a gun found. So we asked, okay, was it sent to a ballistics laboratory? Did you recover spent cartridges? Did you match those cartridges against those found in the gun? Did this gun, was this gun fired? Was there gunshot residue in the gun? What we normally get is what is called an armorer's report that simply confirms that the weapon was serviceable, it was a weapon as described in the Arms Act, and it was in working order. These ballistics tests are rarely carried out. We therefore, on that basis, say that there's no proof that the gun was fired. In those rare cases where there is a ballistics examination that proves that the weapon was fired, we then ask, did you take fingerprints? You have said that this man committed a crime. He tried to murder a uniformed officer. So did you take fingerprints to match against those from the pistol? No. We ask, did you take swabs from his hands to test for gunshot residue, which is a standard forensic test all over the world, to confirm that a person has handled and fired a gun? Almost invariably none. Under the revised guidelines, Ms. Butalia, this is a mandatory requirement. We are now getting, particularly from Assam, Manipur hasn't yet woken up to this, confirmation that yes, this report is there, and we get a forensic report that says yes, this swab sent to us is tested for positive for gunshot residue. When we go back and check, we find neither on the site of the encounter nor at the hospital was a swab actually taken. So this is manufactured evidence. Now all of this, it is possible for us to do in a very rigorous and thorough manner in cases where AFSPA and Section 19 don't inhibit us. In the case of Manipur, and in some cases in Assam, unfortunately, because of AFSPA, the army, the armed forces get impunity. The Manipur police commandos, though, Mr. Sinha, even if they operate under army command, cannot claim that impunity. And we therefore have held, including in cases where the government of Manipur has contested our recommendation, that action must be taken against the policemen and relief must be given. The problem in Manipur that we find is twofold. Firstly, the police are a particularly brutal lot. I completely agree with Mr. Sinha. They are perhaps the most brutal police force that we have come across in the NHRC. And secondly, the government of Manipur is the only state government that insists on standing by its police even in the face of overwhelming evidence that a murder was committed, and refuses either to take action against the police or even to give relief. The standard response we get is that the subcommittee of the cabinet has decided that relief will not be given. So this is an ongoing battle. In the particularly tragic case of Manorama, we have now asked the Supreme Court to implead ourselves as the NHRC, and we want to place before the Supreme Court the full set of our proceedings, to which establishes again, as the Commission of Inquiry already had, that this entire report put forward by the policemen, the security forces involved, was an absolute farrago of lies. What for the future? In 1997, when the Supreme Court first heard this case in AFSPA, the NHRC had pointed out that this was an act which was particularly sweeping powers. And we had said that both in temporal and spatial limitations, there were none. The court, of course, at that stage said that it was constitutional. In the report that we sent out from the NHRC to this UN Human Rights Council, which does a 4-year review of every country, in the 2011 review, we again drew attention to the fact that the AFSPA continued, and that we use these words, that conferred impunity on security forces personnel that led to violations of human rights. The ball really now is in the government's court. We keep on getting this response, which is a standard response from government, that if the army is to operate, it must have some legal cover. Now this, I must confess, I find it difficult to understand, because in my years in the Foreign Service, I worked very closely with the Indian Army on various peacekeeping operations. When they go abroad in UN peacekeeping operations, they operate under a very strict regime of law, the Geneva Conventions. And they operate these days, particularly in what are called Chapter 6 plus operations, which are exactly the sort of operations that they undertake in Manipur or that they undertook in Jammu and Kashmir. And there they do not enjoy this impunity.